Decision podcasts by the New York Prosecutors Training Institute are made possible by Resemble AI. Convert your text to voice at resemble.ai. Find this and other decisions at NYPTI Law. www.nypti.org/law.
People v. 1M Silva Santos, decided on February 20, 2025. Memorandum. The appellate division order should be affirmed. Charged with 2 counts of operating as a major trafficker, a Class AI felony, Penal Law Section 220.77, 1, 2. Defendant accepted a plea bargain under which he pleaded guilty to criminal possession of a controlled substance in the 3rd degree, a Class B felony, Penal Law Section 220.16, 1, and executed a waiver agreeing not to apply to the Department of Corrections and Community Supervision, DOCS, for enrollment in its shock incarceration program, Correction Law Article 26A. At sentencing, defendant asked Supreme Court to enroll him in a shock program or something but acknowledged that he had turned it down by executing the waiver. Although defendant could have asked to withdraw his plea, he did not do so, and he does not seek vacatur of the plea on this appeal. The court denied defendant's request to be enrolled in shock incarceration and imposed the agreed-upon sentence, consisting of a lawful determinate term of incarceration of 9 years and a period of post-release supervision of 2 years. In the uniform sentence and commitment, the court noted defendant's waiver of shock program participation. Defendant's sole contention on appeal is that the shock waiver is an illegal component of the sentence. We reject that contention on the ground that the waiver is not a component of the sentence. See People v. Nieves. Neither the waiver nor the notation in the uniform sentence and commitment directs DOCS to impose a particular form of punishment or prohibits DOCS from calculating defendant's sentence in a particular manner. Moreover, the effect of the waiver on the duration of the sentence is speculative inasmuch as it depends on defendant otherwise choosing to apply for the revocable privilege of participating in the shock program, DOCS exercising its discretion to approve the application, and defendant successfully completing the program, Correction Law Section 867, 2, 4, 5. Contrary to defendant's insistence, the fact that the waiver is noted in the uniform sentence and commitment does not necessarily make it a component of the sentence. See People v. Byan. Concluding that sex offender certification is not a component of the sentence, People v. Guerrero, same for certain surcharges and fees, Nieves, same for orders of protection. While we appreciate our dissenting colleagues' advocacy for the shock incarceration program, we reject their attempt to reformulate defendant's contention, which is expressly a challenge to the legality of the sentence, that is, one including a prohibition on defendants' access to the shock incarceration program. The sentence was illegal because it contained an illegal shock waiver. Defendant explains that he presents his argument in this manner because a challenge to the legality of a sentence is a non-waivable question of law immune from preservation requirements. Defendant cannot waive the right to challenge the unlawful sentence here, i.e., the shock waiver, any more than he can waive the right to challenge the unlawful length of a sentence. We respectfully disagree with the dissent's conclusion that whether the waiver is a component of the sentence is irrelevant to that question. Order affirmed. In a memorandum. Judges Garcia, Singas, Canataro, Troutman and Halligan concur. Chief Judge Wilson dissents in an opinion, in which Judge Rivera concurs. Decided February 20, 2025.
Decision podcasts by the New York Prosecutors Training Institute are made possible by Resemble AI. Convert your text to voice at resemble.ai. Find this and other decisions at NYPTI Law. www.nypti.org/law.